Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your resource for your subrogation and recovery questions. This video, we're going to talk about the civil procedure mechanism of Interpleader. Interpleader is essentially a way for one party to bring other parties in and force them to litigate an issue. We see this most commonly in subrogation cases when a party causes a loss, they have insurance coverage, but that insurance liability coverage isn't enough to pay for all damages. They have insufficient policy limits, but the other carrier who has the liability coverage wants to put the money with the court and let all the other parties fight over it. So, take the example of a warehouse where individuals store boats, motorhomes, and other large vehicles. They don't maintain the property. Maybe an employee is smoking in a non-smoking room and has continued to do so and then throws a cigarette into oily rags, causes a big fire, the warehouse burns down, and now you have hundreds of claimants who have property damage. Their insurance carriers pay for the damage, and now they want to subrogate against that at-fault warehouse. There may be a liability policy in place for that warehouse, and they may have, let's call, $1 million in coverage. But the total claims are over $5 million. So what's the insurance carrier to do? Well, they will hire an attorney and file an interpleader, in which case they will put the funds on hand with the court and say, you guys figure it out, here's $1 million, we don't want to do anything else with this. In an interpleader, the plaintiff then is usually the liability carrier who has the insurance policy to pay for the damages, just not enough to pay for all damages. The defendants, the parties who have to respond to it, are the at-fault parties or the liability policyholder, and any individual or insurance company that may have a claim to those proceeds, to the interpled funds. When you file an answer to an interpleader, you usually respond to the direct allegations that are made and then assert a cross-claim against the tortfeasor, stating that they were negligent, they caused the damage, and you're entitled to recover for them. The heart of the interpleader really allows the liability carrier to put their funds in and not worry about having to defend and litigate on multiple fronts with all the different lawsuits that may be filed. It hopefully consolidates everything and then forces those parties to go through the process of figuring out who gets what money, as well as what other claims may be made or what other damages may be owed by the actual at-fault party. A couple things to note are, you may think that liability is just a foregone conclusion, but usually in that interpleading complaint, the liability carrier has a duty not to admit liability and put full fault on their insured. Rather, they will just state an ambiguous statement that there are claims, we deny all claims, but here's the money on hand. To me, obviously, that's an admission of fault, but for purposes of burden of proof, you still, as a subrogating carrier, have to prove that the defendants were negligent. In most cases, all the parties will stipulate if you're just going to settle for those interpled funds. If a defendant's going to be on the hook for excess damages, they're most likely going to want to argue and litigate that liability decision. That's it for Interpleader in this video. If you have any questions, feel free to contact us at video@rathbonegroup.com. I'm Jason Sullivan for Rathbone Group, and that's the long and short of it.